Everyone, and happy Friday. It is October already. I can't believe how fast this year has gone. But the weather is beautiful. Um, Getting ready for one of my favorite times of the year is Halloween. I'm hoping that we'll get to see some of the kiddos in the neighborhood dressed up and that we'll still be able to do some trick-or-treating and have some normalcy in this uh, pandemic world of COVID-19 that we're living in. So, but today I thought that I would switch gears from what I've been talking about. I've been talking a lot about divorce and assets and child custody. Um, but I also do a lot of business law work. And so I kind of wanted to switch gears and start a series talking about how businesses can protect themselves from lawsuits and basically losing everything that they've been working so hard to establish. So probably one of the biggest areas that a business has some liability in is how they deal with their consumers. So if you are a business owner of a business that sells goods or services to a consumer, then you are subject to the Deceptive Trade Practices Act. And it's an act that was created to protect consumers against false, misleading, and deceptive practices that business owners can engage in and gives them a way to recover anything that they lose as a result of those acts. Um, And that this act can be found in the Business and Commerce Code. It starts about section 17.41, but it is subchapter E of that code. And I would suggest that anybody that's going to operate a business um, read this and be familiar with this particular code section so that you can avoid doing the acts that are contained and be considered deceptive to a consumer. So, who is a consumer? A consumer means an individual, partnership, corporation, the state, or a subdivision or agency of the state who seeks or acquires by purchase or lease any good or service except that the term does not include a business consumer that has assets of 25 million or more, or that is owned or controlled by a corporation or entity with assets of 25 million or more. So that means if you have just under $25 million in assets and you're a business owner, you can sue somebody that provides goods or services to you under the Deceptive Trade Practices Act, and you are considered a consumer as well. So that covers quite a few businesses, especially pretty much all small businesses, because if you've got 25 million or more, or you're part of a corporation that has that much, then obviously you're not going to be a small business. But so what is a good? A good is a tangible chattel or real property purchased or leased for use. So that's going to be something that's um, quantifiable, something that's touchable. And then we have services, which means work, labor, or services purchased or leased for use, including services furnished in connection with the sale or repair of goods. So that pretty much covers most things that a business is going to be open for. Um, and you want to make sure that you know what acts you shouldn't do. Unfortunately, the code actually outlines what we call the laundry list of deceptive trade practices that are considered unlawful. And that can be found in section 17.46 of the Texas Business and Commerce Code. Read these, know these, make sure that you're not doing any of these. And in later weeks, I will go more into depth in some of what some of these actually means. But today I thought I would just give an overview of the Deceptive Trade Practices Act, or the DTPA, and what you need to watch out for just so that you can protect yourself and your business. So, a deceptive trade practice is a false, misleading, or deceptive act or practice in the conduct of any trade or commerce. They are unlawful and subject to certain actions by the Consumer Protection Division, and it gives a bunch of sections of the code. So, it's important to know that there are two different ways that a consumer can act under the Deceptive Trade Practices Act. And that's going to be going to the Attorney General to get some sort of a public ruling against the business and to stop them from doing certain acts. Or they can do a private lawsuit to recover any damages. And something that's very, very important to know about the DTPA is if they find that your act is intentional, willful, um, they can get up to 3 times their damages. So a damage if they are buying, let's say a house from you, could be quite significant. Um, so you want to make sure that you're familiar with this because you don't want to open yourself up to knowingly violating these acts um, and prevent from doing anything wrongful under them. So what are the laundry lists? So the term false, misleading, or deceptive includes, and the important thing to remember here, this is not an all-inclusive list. This includes, but is not limited to these items. But these are categories that have been identified as the most common. So 1 is passing off goods or services of those of another. 2, causing confusion or misunderstanding as to the source, sponsorship, approval, or certification of goods or services. Causing confusion or misunderstanding as to affiliation, connection, or association with, or certification by another. Causing confusion, Number 4, using deceptive representations or designations of geographic origin in connection with goods or services. Representing that goods or services have sponsorship, approval, characteristics, ingredients, uses, benefits, or quantities which they do not have, or that a person has a sponsorship, approval, status, affiliation, or connection with the person which the person does not. Number 6, representing that goods are original or new if they are deteriorated, reconditioned, reclaimed, used, or secondhand. Number 7, representing that goods or services are of a particular standard, quality, or grade, or that goods are of a particular style or model if they are of another. Number 8, disparaging the goods, services, or business of another by false or misleading representation of fact. Number 9, advertising goods or services with intent not to sell them as advertised. Number 10, advertising goods or services with intent not to supply a reasonable expectable public demand unless the advertisement discloses a limitation of quantity. Making false or misleading statements of fact concerning the reasons for, existence of, or amount of price reductions. Number 12, representing that an agreement confers to involve rights, remedies, or obligations which it does not have or involve, or which are prohibited by law. Number 13, knowingly making false or misleading statements of fact concerning the need for parts, replacement, or repair services. Number 14, representing the authority of a salesman, representative, or agent to negotiate the final terms of a consumer transaction. Number 15, basing a charge for the repair of any item in whole or in part on a guarantee or warranty instead of on the value of the actual repairs made or the work to be performed on the item, without stating separately the charges for the work and the charge for the warranty or guarantee, if any. Number 16, disconnecting, turning back, or resetting the odometer of any motor vehicle so as to reduce the number of miles indicated on the odometer gauge. That's a big one. Number 17, advertising of any sale by fraudulently representing that the person is going out of business. 18, advertising, selling, or distributing a card which purports to be a prescription drug identification card, which is issued under the insurance code in accordance with rules adopted by the Commissioner of Insurance, which offers a discount on the purchase of healthcare goods or services from a third-party provider, and which is not evidence of insurance coverage, unless, and there's certain things that will make this okay, the discount is authorized under an agreement between the seller of the card and the provider of those goods or services, or the discount card is offered to members of the seller, or the seller does not represent that the card provides insurance coverage of any kind, and the discount is not false, misleading, or deceptive. So if you're selling third-party insurance discount cards, make sure you read that and see if you fall into one of those exceptions. So number 19 is using or employing a chain referral sales plan in connection with the sale or offer to sell of goods, merchandise, or anything of value, which uses the sales technique, plan, arrangement, or arrangement in which the buyer or prospective buyer is offered the opportunity to purchase merchandise or goods, and in connection with the purchase receives the seller's promise or representation that the buyer shall have the right to receive compensation or consideration in any form for furnishing to the seller the names of other prospective buyers if the receipt of the compensation or consideration is contingent upon the occurrence of an event subsequent to the time the buyer purchased the merchandise or goods. They're basically talking about some pyramid schemes that are out there. Number 20, representing that a Guarantee or warranty confers or involves rights or remedies which it does not have or involve, provided, however, that nothing in the subchapter shall be construed to expand the implied warranty of merchantability. Um, Number 21, promoting a pyramid promotional scheme as defined by section 17.461 of the Business Code. Representing that work or services have been performed on, parts replaced in goods when the work or services were not performed or the parts replaced. 23, filing suit upon a written contractual obligation of and signed by the defendant to pay money arising out of or based on a consumer transaction for goods, services, loans, or extensions of credit intended primarily for personal, family, household, or agricultural use in any county other than in the county in which the defendant resides at the time of the commencement of the action. This is basically saying that you shouldn't foreign shop. You need to file where you're supposed to file your lawsuit. Failing to disclose information concerning goods or services which was known at the time of the transaction. If such failure to disclose that information was intended to induce the consumer into a transaction into which the consumer would not have entered had the information been disclosed. 25. Using the term corporation, incorporated, or abbreviation of either of those terms in the names of a business entity when they are in fact not incorporated under the laws of the state or another jurisdiction. Number 26. Selling, offering to sell, or legally promoting an annuity contract. 27. Taking advantage of a disaster declared by the governor by selling or leasing fuel, food, medicine, lodging, building materials, construction tools, or another necessity at an exorbitant or excessive price, or demanding an exorbitant or excessive price in connection with the sale or lease of fuel, food, medicine, lodging, building materials, construction tools, or another necessity. Which that could be a big one following some of the storms that we've had here recently. So. Number 28, using the translation into a foreign language of a title or other word, including attorney, immigration consultant, immigration expert, lawyer, licensed notary, and notary public in any written or electronic material, including an advertisement, a business card, letterhead, stationery, website, or an online video, in reference to a person who is not an attorney in order to imply that the person is authorized to practice law in the United States. Number 29. Delivering or distributing a solicitation in connection with a good or service that represents that the solicitation is sent on behalf of a governmental entity when it is not, or resembles a governmental notice or form that represents or implies that the criminal penalty may be imposed if the recipient does not remit payment for the goods or services. Number 30, delivering or distributing a solicitation in connection with a good or service that resembles a check or other negotiable instrument or invoice, unless the portion of the solicitation that resembles a check or other negotiable instrument or invoice includes the following notice, clearly and conspicuously printed in at least 18-point type, pretty specific there, specimen not non-negotiable. So those words have to be on those. And I know I get a lot of things that look like a fake check wanting to say, I'm qualified for this much in a loan. But so far, the ones I've gotten do have the notification on them. So number 31, in the production, sale, distribution, or promotion of a synthetic substance that produces and is intended to produce an effect when consumed or ingested, similar to or in excess of the effect of a controlled substance or controlled substance analog. By making a deceptive representation or designation about the synthetic substance, or causing confusion or misunderstanding as to the effects the synthetic substance causes when consumed or ingested. So you can't, for those of you that sell somebody oregano, you could be subject to a DTPA, which seems kind of weird if somebody's buying an illegal drug, but it's there. Number 32, a licensed public insurance adjuster directly or indirectly soliciting employment as defined under the Penal Code for an attorney or licensed public insurance adjuster entering into a contract with an insured for the primary purchase and referring the insured to an attorney without the intent to actually perform the service customarily provided by a licensed public insurance adjuster. Provided that this subdivision may not be construed to prohibit a licensed public insurance adjuster from recommending a particular attorney to an insured. Number 3, owning, operating, maintaining, or advertising a massage establishment that is not appropriately licensed or is not in compliance with the applicable licensing and other requirements, or is not in compliance with an applicable local ordinance relating to the licensing or regulation of a massage establishment. Number 34, and the last one, is a warrantor of a vehicle protection product warranty. I'll get it out in a minute. Using in connection with the product a name that includes casualty, surety, insurance, mutual, or any other word descriptive of an insurance business, including property or casualty insurance or a surety business. So that's a laundry list of things that somebody can sue you under. And in subsequent installments of Ask an Attorney Live, I'll go more into depth in some of those. But just know that there's a 2-year statute. So, and there's plenty of defenses out there available to business owners. And so I would suggest that, you get a good relationship with a business law attorney that can help you understand and keep you out of trouble with some of these things, and to make sure that you're not violating any of these very broad listings of deceptive acts that are out there. The other thing to know about the DTPA are there tie-in statutes. So there's other statutes out there that would tie in to the DTPA that would allow the recovery of 3 times of any damages under the DTPA, in addition to being able to sue under those other statutes. So don't believe that what I just read out is the full and complete list of what would expose you to any kind of liability under just the DTPA or another tie-in statute. So tune in following weeks, and like I said, I'll talk more about this, and we'll talk about some of the defenses that are available. But if you have any questions, as always, feel free to reach out to me. You can reach out to me at Duana, Duana, at boswelltexaslaw.com. You can instant message me through this Facebook page, or you can give us a call and set up a free 15-minute consultation. That number is 832-919-6595. As always, go out and enjoy this weekend. It looks like it's going to be a beautiful one. And I wish you all health and happiness. And if there's ever anything that I can do, please just reach out. I'm always happy to help. And there's no charge or obligation to ask me a question ever. So until next week, everyone, take care of yourselves.